Hello everyone. My name is Krian Butler and I'm the Director of the Global Economy and Finance Program in Chatham House. And it's a really great pleasure for me to be moderating our next keynote session, which is with Dina Kallay, who's the Deputy Assistant Attorney General at the US Department of Justice. And I'm just checking because it looks like Dina doesn't have sound. Do you have sound? Can you hear us okay? Yeah, brilliant. Okay. Dina has a very distinguished career. She's currently responsible for international and policy and appellate in the Antitrust Division. But she's also worked in both the private sector as the global head of competition law at Ericsson, and also in the Federal Trade Commission, working on intellectual property and international antitrust. And just looking back at her bio, I was very interested to see she also spent some time in DG competition in the European Commission, which is a very interesting background for a US competition official. So Dina, thanks very much for being with us. I will just sort of set out a few housekeeping points for today's session. Firstly, Dina's going to do an initial presentation for about 10 or 15 minutes. This is going to be, the whole session is going to be on the record and will be live streamed. And after Dina's presentation, we'll have a Q&A. I will ask some questions, but I'll also give you the opportunity to ask some questions. I would emphasize if you're asking questions, I'd like to get in as many as possible. So please keep them short and to the point, and I'll try and get in as many as possible. We do have a hard stop at 2 o'clock when we will be moving straight into the next session. So with that, Dina, may I hand over to you for your initial presentation?
Yes, can you hear me all right?
Very well, thank you.
Perfect. All right, thank you for having me today. As the International Deputy here at the Antitrust Division, I'm honored to have an opportunity to speak at an institution founded over 100 years ago already to study international affairs. Our hosts here today clearly have their priorities right. I'm going to focus my remarks on competition and air travel today. I'll begin by discussing two recent airline industry examples that we've worked on, one domestic and one international. And then I'll offer some observations on those cases, and focusing on antitrust immunities and the effect that government intervention can have on market conditions. So when President Trump took office, he recognized that hardworking families today are overwhelmed by the cost of fuel, food, housing, automobiles, medical care, utilities, and insurance. And he therefore declared it is critical to restore purchasing power to the American family. In line with these administration priorities, under the leadership of Assistant Attorney General Gail Slater, the Antitrust Division of DOJ has been focused on pocketbook issues that affect people's daily lives. Things like housing, healthcare, food, transportation, entertainment, etc., directly affect the cost of living, and that's why we focus on them. Transportation can be a significant part of household budgets, and in particular, air travel can be very expensive. As some of you may know, with the holiday with loved ones, airline competition matters. Our Sherman Act, which lays out a core part of the framework for U.S. antitrust enforcement, reflects the U.S. Congress's view that competition will produce not only lower prices, but also better goods and services in the long run. With respect to air travel, Congress deregulated the airline sector in 1978 through the Airline Deregulation Act. But for decades, consolidation has mounted in the U.S. airline industry. Between 1960 and 2023, today's 5 biggest U.S. airlines, Alaska, American Airlines, Delta, Southwest, and United, to which airline the customer chooses to fly. This is referred to in the industry as metal neutral alliances. And I'll share with you 2 recent examples where we have been able to make a difference. The first one is the domestic one, and it's called the Northeast Alliance case. The Northeast Alliance, or NEA, was a joint venture between American Airlines and JetBlue, 2 of the largest airlines operating in the northeast of the United States. And it was modeled after the metal neutral international alliances. But this was novel in the domestic context. International alliances, as you'll see, often operate under an antitrust immunity, but such immunity doesn't apply in the domestic context. So NEA was a test case for this unprecedented type of domestic airline alliance. In 2021, the Department of Justice, together with 6 states and the District of Columbia, brought a suit in district court in Massachusetts to block the NEA. In 2023, the district court agreed with our analysis, found the NEA effectively ended all competition between American and JetBlue in the Northeast United States. And it did so through the use of revenue sharing and market allocation agreements. As a result, the NEA was a de facto merger with 2 US airlines essentially acting as one in the relevant market. The end of competition meant there would have been reduced output, fewer choices for consumers, and that price and capacity decisions would be driven by joint profit maximization rather than consumer preferences. Our successful challenge to the NEA in the district court resulted in a court order enjoining and unwinding that NEA alliance. Last November, we successfully defended it at the appellate level in the First Circuit. And earlier this year, in June 2025, we sealed our victory when the US Supreme Court rejected American Airlines' bid to review and overturn the court decision. I'm very proud of our transportation and appellate section's work in developing and securing this positive result. Our victory preserved the win, the trial win, and restored competition in markets affecting 32 million American air travelers. And if NEA was a test case for the question of whether the same type of output coordination and revenue sharing seen in international context could be imported into the domestic context, the answer was a resounding no. The second case I would like to discuss is an international airline alliance, a joint venture between Delta Airlines and Aeromexico. In airline markets, flights between the United States and Mexico. In the international context, US laws limit mergers between international airlines, but provide for a process under which our Department of Transportation, or DOT, may grant antitrust immunity to international airline alliances. As I previewed above, international alliances between airlines from different countries often include features like schedule coordination and revenue sharing that would otherwise be illegal under US antitrust laws, typically also under the laws of the other jurisdictions. But US law gives DOT the authority to approve and grant statutory immunity to international alliance agreements if they are found to be in the public interest, which includes the consideration of competitive impact. As part of its review, DOT conducted a competitive effect analysis. Conducts an analysis. An agreement that substantially reduces or eliminates competition must be disapproved unless DOT makes a determination that it is necessary to meet serious transportation need or achieve important public benefits that cannot be achieved by reasonably available alternatives. In September 2025, DOT issued a final order terminating a prior approval of the Delta Aeromexico joint venture, along with terminating the associated grant of antitrust immunity. During that review, DOT had a number of significant competitive concerns, including the concentration at the Mexico City International Airport and anti-competitive practices in how the Mexican government administered the allocation of slots, that is the authorized takeoff and landing times at the Mexico City International Airport. Thus, DOT approved the joint venture originally with conditions, including the divestiture of certain slots. When Delta and Aeromexico filed a new application with DOT, we at the Department of Justice received notice and we filed comments in the proceeding to support DOT's recent decision to withdraw this antitrust immunity. Unfortunately, I can't comment extensively because this is a matter under ongoing litigation. But our comment, which is public, explained that the antitrust immunity should be narrowly construed and carefully considered, particularly in light of the public benefit standard Congress provided to the DOT, which emphasized the critical importance of competition to air transportation. The comment reiterated that the grant of antitrust immunity must be built on a competitive analysis, including a need to place maximum reliance on competitive market forces and actual potential competition. In particular, DOT found the government of Mexico has continued along the path of intervention and distortion that harmed competition in the markets, including at the Mexico City airport, confiscating slots, prohibiting all cargo operations, and continuing a slot allocation system that advantages Aeromexico, a Mexican airline. DOJ's comments noted that the record evidence suggests that restrictive and potentially discriminatory practices by the government of Mexico have limited entry and expansion by certain carriers at the Mexico City airport and therefore undermine competitive conditions in Mexico. We explained that market access is integral to competition and that whether entry or expansion by rivals can fill in to mitigate the anti-competitive harm is a key part of the relevant considerations for antitrust immunity. DOT's final order declining to extend the antitrust immunity for this joint venture was appropriate in light of the changed circumstances, which took into account relevant factors, including regulatory factors. So there are two observations I'd like to offer and based on these two examples we've discussed. First is that antitrust immunity should be limited and construed narrowly, both as a matter of US legal doctrine and as a matter of antitrust policy. As a legal matter, the US Supreme Court has emphasized that immunities and exemptions from antitrust laws are disfavored. US antitrust laws embody the fundamental national policy in favor of competition, and the strong presumption is that antitrust laws apply across the board. Exemptions distort competition and strip consumers of the protection of competition laws. Our Antitrust Modernization Commission in 2007, which conducted a comprehensive review of US antitrust law, echoed similar sentiments. As a practical matter, immunities and exemptions should be limited because competitive conditions can change, as the Delta Aeromexico example illustrates. Immunities or exemptions that may have been deemed appropriate at one time may become outdated or unjustified based on changed market conditions, changed behavior, or even new economic understanding. But once exemptions are extended, the benefits of an unfettered competitive market are lost, and companies may take anti-competitive actions with impunity. In 2018, our Antitrust Division hosted a public roundtable regarding antitrust exemptions and immunities, and the discussion from that roundtable also reflected a consensus that Congress should not enact future antitrust exemptions and immunities and explore actively studying, sunsetting, or eliminating current exemptions. Even in cases where the anti-competitive conduct does not change the environment around the conduct, the environment, can alter. Which brings me to my second observation, is that regulations and government intervention can make a significant and pivotal difference in the competitive landscape and analysis. In many industries, including the airline industry, there is a regulatory overlay that directly affects how firms in that industry compete. Even in less heavily regulated industries, any number of government actions may change the competitive dynamics by affecting access to inputs, barriers to entry, or some other mechanism. As AAG Slater has emphasized, the American free market system does not support centralized market planning or the promotion of national champion monopolists. It's the free market that decides, not the government. And in the international context, the prospect of a non-US government's regulatory action to disrupt free competition in preference of its own national companies can have serious consequences. In the Delta Aeromexico example, DOJ's comment noted that a foreign national regulatory authority with control over critical airport infrastructure may have an incentive to preference foreign national carriers over American air carriers that are not part of the immunized alliance. Aside from the damage to free markets, one problem with these government regulations and interventions is that they may have butterfly effects beyond specific intervention. Antitrust immunities may incentivize companies to seek additional carve-outs rather than comply with the antitrust laws. And the existence of immunized conduct may have negative anchoring effects. For example, the Northeast Alliance was modeled after immunized international alliances even though no such immunity was available domestically. At the Antitrust Division, we have therefore been wary of the nexus between regulations and anti-competitive barriers, regardless of whether at home or abroad. Earlier this year, President Trump issued an executive order, made it clear that federal regulations should not predetermine economic winners and losers. And along with that line, we, together with our colleagues at the Federal Trade Commission, led a government-wide effort to identify, modify, and rescind anti-competitive regulations across sector, and our work in this area is ongoing. To conclude my remarks, we at the Antitrust Division are runway ready to continue to take action to promote competition, focusing our resources on pocketbook issues, industries that directly affect consumers' daily lives, including the airline industry. At the same time, we will work to curtail anti-competitive regulations and government interventions that weaken competition. The topics I touched on are not unique to US markets. We trust our fellow travelers in competition agencies outside the US, including the UK CMA, will join us, focusing efforts on pocketbook issues, as well as in narrowing antitrust immunities and reducing anti-competitive regulations. I understand that the UK government's regulation action plan already outlines plans to re-energize the regulatory system to support a growth agenda that will support innovation, increase productivity. We wish you a smooth and successful ride. Consumers worldwide stand to benefit from this type of work. Thank you.
Dina,
and I should mention, my speech will be posted on our website, so I know it went fast, and you'll be able to see it in an hour or two.
Dina, thank you very much, and thank you for setting out what I think is actually, a very clear-cut approach, and certainly in terms of the domestic application of this, I can see how there will be considerable benefits for US consumers. You did mention that I think it was in 2018 there was a kind of a roundtable study looking at these areas where immunities may need to be sunsetted or maybe too strong. I just wonder if you could give us a sense of what other parts of the US economy you think may need to be approached in the way that you have approached the domestic airline industry.
Well, maybe I'll share with you kind of a sense of what other sectors enjoy immunities and exemptions in the US.
Sure.
So they include insurance, which has been broadly exempt since 1945. Labor unions, I think that's kind of global. Ocean shipping agreements, banking and securities, professional sports, actually, especially baseball, and communications and energy. And I think a lot of these industries are heavily regulated. And I think the thinking was originally that since they're so heavily regulated, there's not much maybe room left for competition. But as I think I made it clear, it's this administration's belief that regulation is not the way to go. So I would say any of these perhaps should be open. There should be an open season to opening them to competition. Yeah. Because the outcomes are better that way.
Well, thank you. I mean, it does show how much of the US economy is subject to these immunities at the present time. On another aspect of this, which is the interplay between the approach you have in the US and that in countries overseas. Now, we know the US economy is is very large, and in a way, a competition-based approach can still give you national champions, very strong competitors, both domestically and internationally, even if you have a very large degree of competition. Other countries or regions with smaller economies might say, actually, we can't be sure a full competition approach is going to generate what we need in this world where we have to focus on economic security and resilience. And so is there not a kind of potential clash, if you like, between the approach you're taking forward in the US and what other countries might feel they need to do in this world? I wonder if you could just say a little bit about whether you think that could be an issue, and secondly, in terms of the Antitrust Division's approach, whether there are discussions you're having with other competition authorities that will enable you to have a dialogue on this kind of issue?
Sure. So I'm a firm believer that protecting your companies from competition is not good for them. And I think I've seen this directly. Before joining the division, I worked for Ericsson, which was a Swedish company. And I've been a little bit familiar with Swedish industry. Sweden is a small country, has less than 10 million people, but I think is a firm believer in competition, and I think a lot of its companies have done very well globally, even though they come from a small country. I don't want to mention names, but there are a few of them that are household names. So I think it's mistaken to think that that protecting your companies is good for them. I think, they will do much better if they get to compete in the marketplace. It's kind of like the Olympics, right? You gotta compete to lead, to be among the leaders of the world. With respect to cooperation, sure. Since 2001, yeah, for 24 years or so, there's been growing collaboration between competition agencies around the world, mostly through the International Competition Network, the ICN, which now has 154 agencies as members, and the OECD Competition Committee, and then there's a lot of bilateral work. We have excellent bilateral collaboration, for example, with our colleagues from the UK CMA. We need to work together often on cross-border mergers, and sometimes on cross-border conduct to make sure that the remedies don't conflict. And in the multilateral arena, we do work very closely together to promote sound antitrust policy principles. I think things are going well and encouraging in the international antitrust cooperation sphere.
Well, Dina, thank you very much. What I'd like to do now is get some questions from the audience, and I'd like to take perhaps 2 or 3. So I can see a gentleman right at the back. A mic will come to you if you could just wait for the mic.
Can they say who they are? Yeah. Can they identify themselves? Yeah.
Yes, if you could say who you are as well.
Simon Holmes. I think I'm wearing an Oxford University hat today, but I'm also a member of the UK Competition Appeal Tribunal. My question is, I'm sympathetic to what you say about doing away with historic immunities and so on. Very sympathetic. Can you say anything about your use of business review letters, which can look at things afresh and look at them prospectively, and perhaps to give you one example where businesses need to work together to make their supply chains more resilient? But my question is wider than that. What's your current thinking on business review letters?
Great. Let's just see if there's another question that anybody wants to pose before we do that. Nothing else? Okay, Dina, back to you. Business review letters.
Sure. Business review letters, or BRLs, are a mechanism that we have to advise industry on forward-looking project they want to undertake. It has to be forward-looking. They come to us before they adopt it and ask for a type of a comfort letter for our analysis on whether or not we will pursue antitrust enforcement against them if they undertake that undertaking. It's been a hugely useful tool because it allows us to give guidance to the market. The business review letters get posted on our website, and it's also an open process. When we contemplate a business review letter, we invite all the interested parties to come talk to us, which I understand is not always the case in Europe, but we do that here. I invite everybody to look at our business. If you look for the DOJ Antitrust Division business review letters, you'll see the page with 30 years back of business review letters, providing really cutting edge guidance in a lot of important topics. For example, things related to patent pools. I think business review letters really helped shape our guidance and have been very detailed. We invite anybody who thinks they want to do something novel, which is maybe borderline, to come seek a business review letter from us. We meet with them. We often help them shape it in a way that will not violate antitrust laws. And we see it as a really important channel to provide guidance about our thinking. Transparency is good, and Business Review Letter is a nice way to provide guidance, not through enforcement actions, but rather through these public letters. Thanks.
Dina, thank you. Any other questions from the audience? So I have a further question actually on the international cooperation space. So you set out what sounds like the sort of network of competition authorities. It's still kind of working well despite all the other factors that are going on in the world at the present time. In terms of the US government's priorities for that network, I mean, could you say, where do you think the focus should be in terms of those areas, that collaborative network going forward? What do you think are the most pressing international issues that need to be addressed?
Sure, absolutely. So we've just become co-chairs of what we call the CAP, the Competition Agency Procedures. It's the part of the ICN that focuses on due process in antitrust investigations. We think there's important work to be done to spread basic due process principles around the world, even if realizing that different countries have different legal regimes. We think things like, the right to defend yourself and attorney-client privilege, the right to be told what are the allegations or the theory of harm against you, etc. These are really important. I'm sure it sounds basic to a UK or US audience, but it's a broad world out there. And so due process in antitrust investigation is a key priority. Another project we started actually this year is on corporate compliance programs. We would think it'd be extremely helpful if there'd be one global set of recommendations for how companies should structure their compliance programs. You can't structure a different program in each country of the world. And there hasn't been one centralized guidance. So we think that would be very helpful because it will allow the private sector to work with us. Our resources are limited. Antitrust lawyers in-house, they work really with us, shoulder to shoulder, to try and keep antitrust violations from happening, and having a good guidance for what a compliance program should look like, and convincing their C-suite that they should get the budget to put together an effective compliance program is super important. Yeah. So these are two areas that are close to our heart right now.
Thank you very much. I mean, on the process point, I mean, in other areas of international cooperation, speed is a critical issue, particularly, some of the frustrations with the way some of the WTO processes have operated in the past has been to do with speed. Do you think that's an issue in the international cooperation on competition authorities? I mean, do you feel that things need to move faster when, for example, a big merger comes up and it needs to be addressed by a number of different competition authorities? Or do you think we have it about right at the moment in terms of the balance between, due diligence, proper assessment, and so on, versus speed on the other side?
So mergers have a statutory timeline, usually about 30 days. So right. They move. There's nothing right. stops them. It's interesting with respect to conduct investigations. I've been in the view in the past that it would be helpful to try and curb them somewhat, maybe, or at least have a recommended length, because they can take years and consume huge resources. I think it's a balance between not dragging over years, but of course allowing enough time for the company to defend itself. It's an interesting question. But in terms of cooperation between the agencies, it's the speed of light. So that's not an issue. Yeah. Right. Because it's mostly informal. Yeah.
Well, Dina, sadly, I'm afraid we're out of time. So let me thank you very much for being with us today and for your speech, which, as you say, will be published online very shortly. And perhaps I could ask the audience, and actually thanks to the audience for the gentleman over there for their question, but ask the audience to join me in thanking you for joining us today. So.
Thank you. Appreciate it.